Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome to the Men's Divorce Podcast. I'm Jason Lasser. Today's topic is death and divorces, estate planning implications regarding death and divorce. I'd like to welcome Iana Benjamin. She's an attorney in our Jacksonville office. Iana, can you introduce yourself?
Yes, hi, I'm Iana Benjamin. I am in our Jacksonville office. I practice in Florida and the District of Columbia.
I'm Jason Lasser. I'm licensed in Pennsylvania. I've been with the firm at Cordell for going on 15 years now, and been practicing for just under 18 years. So this is a topic that's always interesting to me because it's something that we're not directly involved with every day as divorce attorneys, but it is something that has great implications on our clients and what they're going through. So, Iana, why don't you tell me why you think it's important enough that it's a topic of today's podcast?
Yeah, Jason. So I've been with the firm for 5 years now, and I see it every time with clients. They don't think about what happens post-divorce. Yes, they get that consent final judgment or divorce decree, and they're like, okay, yeah, we're done. Great. The divorce is over. But there's still some things that they need to do or get done that they don't always think about. So it's important when I draft my closing letter to them, I always include the specific things that we're going to talk about today.
So tell me, what does happen when a divorce is finalized? Because I agree, most of my clients, they get their divorce decree out of sight, out of mind. They're done with us, and it's been most of the time a grueling process, and they just want to get on with the rest of their lives. So tell me why estate implications are then important to consider after the divorce is final.
Because oftentimes their desires, right, that their final desires. So for example, the will, you don't think about your will after you draft it, especially when you're going through a divorce. It's the last thing you're thinking about. But it's important to review something like your will because it would have your former spouse probably benefiting from everything once you pass away. So that's one of the first things I always tell clients: review any wills that you may have so that you can revoke that will and draft a new one with a new beneficiary.
Does the will still remain in place after the divorce is final?
No. So in Florida law, no. Once you're divorced, generally it goes away. It's no longer valid. But it's still something you want to proactively take steps to actually revoke and actually put a new one in place to list new beneficiaries.
So while the portions regarding your ex-spouse are invalid, the rest of the will is still valid, and there might still be some lingering effects or impacts that your ex-spouse could still have residually. Is that fair to say?
Absolutely. You're right on the money there. Yes.
Okay. So give me an example. Is it something like executor or...
Yes, that's a big one. The executor is still in place. That doesn't change, right? So in Florida law, just of course that beneficiary in terms of your partner, your spouse, definitely won't inherit anything. But your children will still inherit items in your divorce, and also your executor is still in place. So if you ever want that to be changed, so say your will named your former spouse as an executor, that's still in place if you even if you get divorced. So you definitely want to make sure that you update that or revoke that will and draft a new one.
So you could have a situation where you've been divorced for 7 years, and then unfortunately you pass away, and then it's your ex-wife who's in charge of distributing your estate per the terms of your will. Is that fair?
Yes. That is absolutely fair. And I haven't seen it personally happen, but I was reading something recently that former spouses, they're still relatively civil because he sends her an anniversary card for their anniversary every year, though they've been divorced for like 22 years. And he still had her as his executor on his will. So yeah, it could be a real weird situation.
Yeah, and I think it's important to note here, we're talking about Pennsylvania and Florida. That's where we're licensed in addition to District of Columbia for Iana. But if anyone listening to this podcast has specific questions in other states, there's a good chance that what we're saying might not be applicable in your state. So please make sure to contact an attorney in those states, or the states you have specific questions of, if it's not Florida and Pennsylvania, because the laws are vastly different in every state. And we have attorneys in most states across the country, so you can look up a Cordell attorney if you have further questions as well, and I'm sure we can get you pointed in the right direction.
Absolutely. I agree with all of that.
Okay, so what about a healthcare proxy or a medical power of attorney? Are those revoked by a divorce decree as well?
They're not, at least in Florida, right? So they're not revoked. So generally with estate planning, you would do a will, you would do a healthcare proxy, you would do a power of attorney probably, or a living directive, and those are not revoked per a divorce decree. So it's important to review those documents and update those documents immediately, because if something happens to you, your former spouse would still have a lot of power over your health.
Right. So in theory, to play the same scenario we did before, you could be divorced 5 years, you could fall ill, and decisions are being made about the end of your life, whether medical treatment should continue or not, and it's your ex-spouse that's making those decisions for you.
That's why it's so important post-divorce to review these documents. It's not...
Yeah, you're going to want to clean that up, probably. Yeah.
Yeah.
And again, something that most people don't think about.
Yes.
I know you said you're including it in your closing letters, but I would imagine most folks going through a divorce they're just on to the next phase of their life. They're not thinking about all the loose ends and what their intentions actually are and how they've changed post-divorce, right? And making sure those intentions are covered by the appropriate legal documents.
And most people don't like thinking about death on the whole, right? So if you ask most people probably don't have a will or don't have a lot of these things in place. So it's a conversation I like to have with clients, that it's a hard conversation sometimes because we don't like thinking about death, but you want to make sure these documents are in place and updated according to your present desires.
Sure. And what about retirement accounts, pensions, beneficiaries for those types? I would assume those have to be amended as well.
Yes, those documents need to be amended as well, especially retirement and life insurance. So retirement depends on, of course, where you work, and for certain states too. Well, I'm specifically thinking about the military here. So of course, with military retirements, those are a little funky and require some more detail because your former spouse may be entitled to some of those proceeds from a pension. But for the most part, you can update those beneficiaries to reflect a new beneficiary, not your former spouse.
I know in Pennsylvania for a lot of plans, you actually to modify a beneficiary on a retirement account when it's not the time of the year to change, to opt in or opt out of plan changes, you need a divorce decree. So you would need to submit that to your plan administrator so that they can then change the beneficiaries per your selection. You do need at least in Pennsylvania, proof of divorce to be able to change those. Is that the same in Philadelphia or in Florida?
Yes, it's the same thing in Florida. You definitely need that final judgment to say, hey, yes, I can update. And oftentimes that's what I direct clients to do, use that to do all of the transactions.
So what advice would you have for clients that are considering a divorce? Nothing's been filed, but a lot of times when clients come to us and a divorce is filed, it's too late to do a lot of things that they would have liked to have done months earlier. Is there any estate considerations they could make if they're starting to fight with their spouse and they're not ready for a divorce, but it's becoming increasingly more possible? Is there anything that they could be doing from an estate planning perspective?
Yeah, from a estate planning perspective, you can actually start thinking about it, right? So there is no prohibition against changing a will or We didn't mention trust yet, or a trust midway before you even think about getting divorced, right? Because again, a will or a trust is for your desires to be fulfilled post-death. So you can make changes to those early enough in the process so that, post-divorce, you're not having to do it. But yes, you can definitely start if you have the proactive knowledge to start thinking about divorce, and you can start thinking about estate planning, then you are way 10 steps ahead of most persons, because people are not thinking along these lines, which is leading me to that question of thinking about telling clients about postnups and prenups and how crucial they are. If you're at a place of trying to think of a divorce, you're probably not thinking of a postnup then. But it's important to think about these checklist items of, listen, I need to probably update my will. Yes, I need to probably think about guardianship for my children if, that's an issue regarding if there's substance abuse issues and mental health issues, and you want to think about that. There are checklist items that you can think about pre-divorce as well. Yes. So Jason, yes, it's important for clients to review their prenups and postnups if they have one. I also like to tell clients, especially post-divorce, that if they're thinking about divorce again, that it's important for them to get a prenup done. I know it's a taboo thing to think about, but it's crucial. It saves them so much time and resources in the event of a divorce. So definitely you want to post-divorce update a postnup or prenup that you may have had. And if you don't have one, definitely get a prenup and or postnup when you're thinking about getting married again, so it can save you in a divorce. All right. Well, thank you so much. It was so great to join Jason on this podcast.